Say Thursday, because that would be the best guess as to the earliest we could possibly get it. And I think we all agreed not to start till Monday, but I'd hate to tell her Friday, us be done earlier on Thursday, and then have to wait Friday just to impanel them.
Okay. Would you agree with that, Mr. Sampson?
Yes, Your Honor.
So Thursday afternoon, we have a full day.
Yeah, I think Thursday afternoon.
Okay, so have them come back Thursday at 1 for peremptory challenges, and then at that point, if we are ready to go, we will have everybody at least read the pre-admonitions to them, but not swear until we have them all here on Monday.
Correct. That would seem reasonable. As long as I think we've all agreed not to open or call witnesses till Monday, that'd be great.
Yep.
Right away, we're seeing this trial operate on a very deliberate schedule. The lawyers are sorting out jury logistics before the actual trial gets underway, and even a one-day difference matters. But the real headline is coming next. The defendant is about to confirm a major waiver involving who gets to decide the sentence.
That's sort of the plan that I've been sticking with as well, so no change to that. Anything else that we wanted to talk about the jury selection protocol, because it is different from how we usually do it?
No, Your Honor.
No? Okay. Mr. Davis, my understanding is that Mr. Stampt has made you aware that you have the right to have the jury sentence you if they come back on a first-degree murder verdict, and you have decided to waive that right. Is that correct?
Yes, ma'am.
Okay. So what that means is when I am...
Here's the key legal moment. The defendant is waiving the right to have the jury determine the sentence if there is a first-degree murder conviction. That doesn't decide guilt or innocence. The jury still has that job. Instead, it changes who handles the punishment phase, and the judge makes sure there's absolutely no ambiguity about that choice.
Talking to the jurors, I'm not going to tell them what the potential penalties are for first-degree murder. Additionally, I'm not going to ask them if they can abide by those penalties and come up with a sentencing agreement or sentencing decision. And then at the end of the day, if that is the verdict, it would be me sentencing you on that as well as the enhancement. Is that your understanding of everything that would happen given this waiver?
Enhancement.
Yeah. So in general, the defense would have,
Listen carefully to the distinction here. The possible sentence and the enhancements are separate pieces. The judge is explaining that the enhancements can carry their own consequences, and this is why the waiver matters so much. The courtroom isn't just talking about a verdict. They're establishing exactly what happens after that verdict.
Jury would be able to sentence you on the first-degree murder portion. That carries either 20 years to life, or 20 to 50 years, 20 to life, or life without the possibility of parole. In any case, if there's an enhancement, and in this case there are two enhancements, there's both the gang enhancement as well as the deadly weapon enhancement, that is left up to the judge. In this case, if it's a first-degree murder, that has to be an equal and consecutive 20 to life sentence or life without the possibility, 20 to 50 sentence, 20 to life, or life without the possibility of parole. So that would be up to the judge sentencing, no matter what the jury found. I'll give you a moment to consult with Mr. Sanders.
I have a question while they're talking. Because you intend to impanel 36, is that 8 and 2 instead of 8 and 1?
Yes.
So it's 10 total.
Yeah, so I'll go over that, the general guidelines at this point.
And now we get another important detail. The court expects this trial to potentially run 4 to 5 weeks. That's a massive commitment for everyone involved: jurors, attorneys, witnesses, and the court. The sentencing waiver could streamline part of the process, but this is still shaping up to be a lengthy proceeding.
Once I finish with the canvas.
Thank you, Your Honor.
Okay, Mr. Davis, do you understand then what we've gone over?
Yes.
Any other questions that I can answer at this time?
All good.
Okay, and you wish to waive your right to have the jury sentence you on the first-degree murder if that is their verdict?
Yes.
Okay, perfect. I will have this stipulation and waiver of penalty phase, or penalty hearing, filed. That should cut down the potential for how long this trial will last. Previous discussions had been 4 to 5 weeks. Is that still accurate state? To qualify the jury for?
Yes.
Mr. Samp, do you think that sounds reasonable, or do you
No, Your
suggest a
Honor,
longer?
I believe that's reasonable. I do have one concern that's popped up that I wasn't anticipating. I might be asking the court for a day to depose,
A day?
a day to depose Steve Wilson on August 19th. So apparently my office had submitted a deposition subpoena for Mr. Wilson to make an appearance on a separate issue that's not related.
Unrelated to this case, you have a legal matter.
Correct,
That
Your
may
Honor.
have to occur.
And that would be on the 19th.
Okay, and let me look.
Now, my concern is, of course, I would have moved it, but the
Even before the jury enters, the attorneys are juggling another moving part, a separate deposition that could collide with the trial schedule. And notice the judge's approach. Rather than derail everything immediately, the court says they'll deal with the issue if it actually becomes necessary. Now the focus shifts to something crucial, exactly how this jury will be selected.
problem is, though, that particular
And it would be in the
issue.
afternoon?
it,
Well, so here's why I'm saying that. I had gone dark on several of my civil days, but I was going every other day so I could keep my civil cases on track.
Yes.
So the 19th, we are starting at 1.
okay.
So if it's able to be in the morning, let me know. If it's something that has to be in the afternoon, let me know as soon as that happens.
I guess it just depends on how long we talk in that deposition, Your Honor. It might go a little longer. I'm hoping to get it done as quickly as possible. I just want to let the court know that we may get a little chatty in that one. And I'm anticipating that there will be a motion filed by the state anyways on that one to stay that particular deposition date because of some type of privilege that might be asserted. So as a result, I think there might be some technical things. We just
Okay.
have not received any notice so far.
So I guess if that's something that comes up, we can address it as it comes up. I will definitely try to work around your schedule as I can. I understand it's hard to block out an entire month for trial. So just keep us up in the loop.
I will.
And then, if possible, do it in the morning, but if not, I completely understand.
It's going to start in the morning. I just don't know if it's going to traipse into the afternoon.
Sure.
My concern. Yeah.
Okay, cool. Anything to add on that? Looks like nothing from the state. Let's go over our jury selection protocols real quick, just so I have them on record, and then we'll bring our jury in. So this is going to be just sort of a special selection process. We're going to start with a panel for the hardship challenge, the hardship issues, and then for the second half of the hardship challenges, as well as the individual questioning, we're going to move into individual sequester. That's the agreement between the parties, correct?
Yes, Your Honor.
All right. So it sounds like you guys know what's going to happen a little better than I do because you proposed it. So I'm going to sit back and...
And that's the setup. For alternates, peremptory challenges, individual questioning, and jurors potentially being questioned separately so one person's answer doesn't influence everyone else. In other words, the court is going unusually deep on jury selection. And for a trial expected to last weeks, choosing the right jurors may be one of the most important steps of all. Now, the jury finally comes in.
And watch, and I've got kind of the idea of what's going to happen there. The alternates in this case, we are going to do 4 alternates given the length of the case. And so we are going to then they're going to be in seats 13, 14, 15, and 16 once impaneled. Preempts, like usual, we're going to exercise using the paper pass back and forth method. As we've already discussed, we will be bringing the jurors back for the peremptory challenges. So I anticipate having this full box filled on that day, which will be Thursday at 1 p.m. Do we anticipate once we get into the sequestered voir dire doing cause challenges up here at the bench?
Whatever court's preference is.
Let's try to do it that way and see how that works.
Yes,
okay?
ma'am.
So then after every juror, we'll have everyone approach, say pass or challenge. Okay, perfect. If you exercise all your preempts, you must use one on the alternate chairs. Mr. DiGiacomo brought up a very good point because we have extra peremptory or extra alternates here. You are getting an extra peremptory challenge. So you're going to get 10 total. Your last 2 have to be used on those alternate chairs, okay?
Yes, ma'am.
Waiver of one challenge is not a waiver of all. And then, like we just talked about, the challenges for cause will be up the bench after each side is finished with their questioning. If it happens earlier, you just don't think this is a suitable person, and it becomes very apparent, and you just guys want to approach in the middle, let's do it that way. Okay? We don't have as many issues ultimately with other jurors being tainted by answers, so we can do a deeper dive than usual, given the individual sequestered nature.
Yes, Your Honor.
So, anything else?
Nothing to say.